Welcome to Wales Tech Week 2021. Thank you to our partners. Enjoy the session.
Hello everyone, and thank you for attending this webinar today. My name's Elliott Davies. I'm a patent attorney at Wynne-Jones IP, which is a legal company that specializes in protecting the intellectual property assets of individuals and companies. Intellectual property can arise out of research, development activities, testing, and the like. And with the latest advances in assisted living and smart homes, my talk today will consider the various intellectual property rights for protecting the technological advancements in this area. So to begin with, I'd like to take a brief look at the concept of a smart home and assisted living, and then outline some of the key rights which can be used to protect the advancements in this field. I will then briefly consider how you can leverage publicly available data rights and information relating to intellectual property rights to assist you with your R&D activity and develop a commercial strategy. Finally, I'll briefly discuss the concept of an IP audit, which will help you identify your rights and nurture your IP portfolio. I've also been told if you have any queries or comments, I think they will be best placed in the comments section on your screen. I'll try and address these as I go, but if I miss any, I'll try and pick them up at the end. So let's first take a look at smart homes and assisted living. So the concept of a smart home might get you thinking of something like you've seen in the movies, like the Jetsons. But with the success and uptake of the smartphones and tablets over the last few decades, and the ever-increasing, ever-present internet connections, what used to be an idealized concept is fast becoming a reality. Smart homes rely on access to a network, and specifically the accessibility of various home systems and appliances to a network. As most homes now have an internet connection, homes that were once considered to be dumb, if you like, are now beginning to get smarter. This is because devices and systems which are connected to a network can interact and be controlled, such as via an app on a mobile phone. And this can be done irrespective of whether you are actually sitting on the sofa in your home or by the pool in Barbados. So the Internet of Things is a phrase that refers to the devices and systems that are interconnected and identifiable through various networks. And this connected arrangement of devices is getting bigger and better every day. In fact, all of the electronics in your home are fair game for this technological revolution, and some of the home systems which benefit from this interconnectivity are illustrated in this slide. For example, the interior and exterior lighting can be programmed to switch on and off at certain times, or lighting levels can be varied according to the time of day. Smart thermostats can detect when you're home and when you're away, so that your heating operates only when it's needed. The thermostats can be equipped with sensors that you can put in the rooms you occupy most frequently, so that the thermostat operates on the basis of where you are in the house. You could even switch your heating on while sitting in your car before you leave work, so that the house is warm when you get home. Similarly, cameras enable you to keep a watchful eye in your home, especially while you're away. Indoor cameras can help you monitor children and loved ones and can offer a two-way communication link so that an elderly relative, for example, can easily talk with you via an app on your mobile. Surveillance systems can also be used to monitor daily patterns of activity and to issue an alert in the event that some unusual behavior or characteristic is detected. This can be useful when monitoring persons who wish to maintain their independence, but who may be vulnerable in some way. Some models of cameras from the likes of the manufacturers of like Ring and Arlo, they incorporate lights that can illuminate your way around your home. And you will have most likely have seen cameras incorporated into doorbells that can monitor your front porch and let you interact with visitors without the need to approach the door or even be at home at the time. Home appliances, including cookers, kettles, TVs, can also be controlled to ensure they operate within safe limits. Smart detectors like smoke or carbon monoxide detectors can be used to alert the emergency services directly, or a dedicated carer, for example. And door locks and garage doors can also be arranged to open and close automatically on instructions from your mobile phone. So as you can see, the possibilities for making a home smart are endless. The connected arrangement of devices and systems can assist individuals in maintaining an independent lifestyle in their own home, while providing them with a degree of support and reassurance. But in all cases, making a home smart requires the use of some kind of technology, and this technology needs to be connected via a network. The development of the technology and the communications infrastructure is thus a fast evolving area. And so for companies who operate in this field, it is necessary for these companies to protect their developments, their intellectual property, in order to gain a competitive advantage. So let's take a look at what we mean by intellectual property and the various intellectual property or IP rights which can help protect this property. So broadly, intellectual property is something which is intangible. It's an intangible form of property and is the product of one's thinking or intelligence. Any original creation can be considered to be intellectual property. And there are various types of IP rights which serve to protect the different types of original creation. The most common rights include patents, which are used to protect technical creations, like inventions. You have trademarks, which are used to protect trade-in names, brands, and logos. You also have designs, which are used to protect visual appearance, namely the look of a product. And then you have copyright, which is a broad-ranging right that's used to protect things like literary works, brochures, web content, programs and source code, and also pictures and artistic works. There's also confidentiality rights, or NDAs, which are used to prevent third parties from disclosing information. And then there's trade secrets, which are used to protect commercial know-how and proprietary information. There are other rights like plant variety rights, but it's not that relevant to today's talk, but I thought I'd just mention it in passing. So just considering the more relevant rights to this particular sector of assisted living and smart homes, let's look at the patents. So patents are used to protect how things work, the technical function, and can be used to protect apparatus, systems, methods, processes, assemblies, a number of different things. But they are obtained by a registration process, which involves preparing and submitting a patent application at the Patent Office, or as it's known today, the UK Intellectual Property Office. The invention is then assessed by an examiner to determine whether the concept is sufficiently different to what's already known, and if it is, then you're awarded a patent. Once the technology has been developed, you may wish to encapsulate this technology in a nicely designed housing, for example. And that particular design may offer a particular attraction itself. So to protect the look of the product, namely the shape and the configuration, you need a design right. And there are two basic flavors. There's the unregistered right and the registered right. Now, the unregistered design right is a right which is acquired automatically once the actual design is created, whereas the registered right involves preparing and submitting an application at the UK Intellectual Property Office, just like a patent. However, registered designs offer a better protection than unregistered designs because they can protect more things. They can protect things like color, textures, contours, rather than just shape and configuration. And they can be much easier to enforce and last longer. So once you've got your technology protected with a patent and you've got the look of your product protected with a design, what about your brand? What about your trade-in name? So to protect this, you need a trademark. And trademarks are used to distinguish one trader from another, and the particular trade-in name or logo can be protected with a trademark right. This can be acquired simply through the use of a particular mark in the course of trade, and this unregistered use of the mark is often indicated with the symbol TM. On the other hand, you can obtain a registered trademark by filing an application again at the UK Intellectual Property Office. And once that trademark application is registered, you can then indicate that mark with the R in the circle. It's the R in the circle which is the registered indicia. Just to say a little bit more about patents, since patents are most likely the dominant right to protect devices and systems in the healthcare and assisted living sector, it's important to note that a patent only entitles you to stop third parties doing what you have protected. They are negative rights. For example, having a patent on a product does not entitle you to make and sell the product. It only entitles you to stop third parties from making and selling your product. So the classic example is if I have the patent on the wheel, but you have the patent on the bicycle, then you may not be entitled to commercialize your bicycle because you potentially would be infringing my patent on the wheel. So patents, like other forms of property, are business tools, and they need to be leveraged appropriately to maximize their return for your business. And patents, like other intellectual property rights, are territorial. If you need a patent in a particular territory, like the UK and the US, then it would be necessary to file a patent application at the local patent office, so the UK or the US patent office. And once granted, patents can last for up to 20 years, subject to the payment of renewal fees, which in the UK are payable annually. So once your technology, your products and your systems has been protected, you should also consider the activity of your competitors. This is done by carrying out searches and performing an analysis of the data and the statistics. Namely, you consider the so-called analytics. So analytics allows you to understand the technical landscape you are operating in, and it provides you with some valuable intelligence on your competitors. It provides reliable, relevant information on which you can make informed commercial decisions. Patent analytics can also unlock detailed insights to help you plan and create strategies for your intellectual property rights, and it can help steer your particular research and development streams. It's much more than just a valuable tool. Analytics is potentially a business-critical strategic service, and there are 4 principal types of searches which can be undertaken to obtain this information. So, as you can see on this slide, that the searches include a watching and monitoring search, a patentability search, an FTO, or a freedom to operate, also known as an infringement search, and an invalidity search. So let's take a brief look at each of these. A watching and monitoring search is used to keep track of the activity of various companies and individuals by monitoring for newly filed patent or trademark applications, for example. And that's because knowledge of this activity can help reveal information about a company and can also enable you to take early action to challenge and prevent a patent or trademark application proceeding to registration. For example, suppose a monitoring search revealed that a company X has filed a patent application for a product. This may give some insight into whether company X is looking to diversify into a new product range or make a new service offering, or whether your R&D may result in a product itself which could infringe the rights of any patent granted to this company X. So armed with prior information or early information about the activity of your competitors, this can help you make your own commercial decisions about the direction of your R&D, for example. So looking at the second search, so most people will have heard of the phrase patent search. However, many people incorrectly assume that a patent search will accomplish 2 goals. They think it'll provide some information about whether a particular product may be patentable, and also whether they may be infringing any patents if they were to move forward and commercialize their product. However, it is important to distinguish between these 2 completely separate patent searches. They need to be separated out into a patentability search and the freedom to operate search. So a patentability search focuses only on whether your product or device may be patentable. And to be patentable, a concept must never have been disclosed anywhere in the world prior to the filing date of your patent application. So just thinking about that point, if you make a disclosure of your concept before you file a patent application, that could be a big problem. That's irrespective of whether anybody else has made some other publication. So a patentability search is not limited to searching just for patents. It can include a search for any published information, including magazine articles, a lecture, a YouTube video, or a scientific publication, for example, and even prior use. So if you used or demonstrated the use of your concept in public, that could be a problem. Anything which has been published anywhere in the world prior to filing your patent application can be used to challenge the patentability of your concept. And so a patentability search can draw on any resource to provide you with information about the state of the relevant art. So this type of search is typically performed before filing a patent application to determine the prospects of patentability. It's also often used by financial institutions before they will offer a loan or grant for R&D. They will typically require some form of patentability search to determine whether the product may be protectable with a patent application, for example, before they'd release the funds. Alternatively, if you are more concerned about whether your product may infringe the patent rights of a third party, then it's necessary to perform a freedom to operate or an infringement search. Freedom to operate search is restricted to patents which relate to your product and which are active in the territories in which you intend to commercialize the product. That's because patents are territorial and they relate to a specific type of invention. They offer a defined scope of protection. So as patents have a maximum life of only 20 years, the search is restricted to applications that have been filed in the last 20 years. And if you only intend commercializing your product in the UK, for example, then the search could be restricted just to UK patents. An infringement search is typically quite time intensive to perform because it requires a careful analysis of the protection afforded by the various patents that are retrieved. However, this time can be minimized by further filtering the search to patents filed by particular competitors, for example. Now, an FTO search should be considered relatively early in the product development phase, since it may be possible to avoid any problematic patents that are identified, which may otherwise restrict your commercial activity, because at that point, you can possibly modify your product to avoid infringement. It can be more costly to redevelop your product to avoid infringement once you are nearing the product launch phase. However, if you do identify problematic patents, then it's also possible to challenge the validity of those patents and possibly invalidate them to effectively clear the way for you to commercialize your product. An invalidity search is similar to a patentability search, but is restricted to publications made before the filing date of that problematic patent. And that's because only publications made prior to the filing date can be used to challenge validity. So this type of search can be used in conjunction with a monitoring, watching type search, so that once you become aware of a possible problematic application, you can take steps to identify prior publications, which can then be used to challenge the application and hopefully prevent it becoming registered. An invalidity search is also typically used when you have received a letter informing you of a potential infringement action, a so-called cease and desist letter. It's a common defense in patent infringement proceedings to claim that a patent is invalid. So if you have relevant publications, which is what we refer to as prior art as it's known, then this can be useful in negotiating your way out of an infringement action. So patent analytics can offer a wealth of patent information, and there are various so-called infographics and landscaping methods for assessing and visualizing large amounts of data. Patent landscapes help facilitate the evaluation of patents and are very useful for identifying potential competitors, partners, potential licensees, infringers, and can even provide you with some commercial opportunities. A landscape consisting of 1,000 patents can often be investigated and reduced to just 10 that are relevant, so it's a much easier data set to digest. So the image on this slide was entitled "The Year of the Wearables" and is representative of patents relating to wearables such as those used for use in the healthcare sector. The peaks and troughs show areas of patent activity identified by the associated keyword. So you can see the number of patents filed in a particular technical sector or technical subsector. And the proximity of the peaks shows the level of similarity between the clusters of patents, and it effectively show how crowded a particular sector is, and possibly how little room there is in it for new R&D. The landscape also shows how potentially lucrative the main players think a particular market is or will become. So you could see whether there may be a hotbed of activity. This could be the next up-and-coming technical sector. Other information can also be overlaid to define technology areas or geographical areas, for example, to make the data set even more rich and easier to analyze in context. So the ultimate goal is to provide a data-rich visual analysis of patent data for a particular sector or technology so that R&D teams can identify areas of risk or opportunity. So what about your intellectual property and your intellectual property rights? Well, the acquisition of intellectual property rights, like patents, and also their maintenance, the payment of renewals, has become increasingly strategic over the last 10 to 20 years. And historically, the operations of the legal division of a company, particularly the IP department, who was responsible for obtaining the patents, was disconnected with the board of directors. So the acquisition of these rights took place independently of the actual business strategy. However, the rise in importance and awareness of these assets raises questions about how best to employ them, just like any other assets, to achieve the objectives of the company. And this shift in mindset was captured by Bill Gates in 2004 with this statement, which I think is very relevant. Now, an IP strategy is difficult to define. However, a business strategy can be thought of as the development of an action plan to enable a company to generate a sustainable stream of profits. So this can be achieved by sustaining higher prices than your competitors, or lowering your costs, or acquiring a larger market share than your competitors. But IP rights enable you to achieve these things. So an IP strategy should clearly align with the business strategy. An IP strategy should utilize your intellectual property rights to leverage the higher prices, to leverage an increase in market share and maintain lower costs than the competition. So what do you need to do? Well, in the healthcare market, including smart homes and assisted living, products compete on features and performance. So consider the difference in price, for example, between an Apple Watch and one produced by a lesser brand. Now, a big part of the difference in price is due to differences in performance and features. And many of the technologies which provide these differences may be patented. So by precluding competitors from adopting various technologies, it's possible to ring-fence a market and ultimately command sustainably higher prices. However, before you can leverage any IP rights, you will need to perform an IP audit. And funding is available for this via the UK Intellectual Property Office. So an audit is typically performed by a patent attorney, and provides a snapshot of your IP rights. It gives you with a report which identifies the rights which you have as a business, and it'll outline some steps for you to manage and harvest all your intellectual property rights. It may also consider third-party agreements and even potential infringement risks. So it's important to identify your core products, identify the best rights to use to protect the products, ensure that you maintain ownership in any rights derived from collaborations or partnerships with third party, and also consider your freedom to sell and market your products. And once armed with this information, it's then possible to see what needs to be done from an IP position to support your business strategy. For example, when selling your products, you may decide to sell them directly or via a distributor or agent. And this is where you can certainly leverage your IP rights to negotiate a favorable deal. So, for example, without the benefit of a patent or a similar right, it could be difficult to command a premium royalty as part of the distribution agreement. So you should make it clear in your agreements with distributors that you have associated IP rights. And when selling your products, it's also quite important to mark products with your patent number, for example. This is just to inform third parties of the existence of your rights, so that in the event your rights are infringed, they can't claim that they were unaware that there was a patent relating to that concept, that product. And there's some truth in the old saying that you cannot manage what's not measured. So companies big and small should set some metrics, such as performance indicators, to measure the performance of their IP rights. So the metrics should be tailored to what your business stakeholders want, what they want to measure, such as the effect on financial results, the efficacy of IP spend, and IP spend per profit, for example. And it's also important to make periodic reviews of your portfolio, such as every 6 months, so that you're familiar with the status of your IP rights and to ensure that the rights are relevant to your current business strategy. So in the fast-moving sector of personalized medicine, for example, it may not be worthwhile going to the expense of renewing a family of patents relating to a particular concept when there's no longer a market appetite for that concept. Having said that, a patent could also provide an income stream by virtue of licensing. We can conduct searches to see where your patents have become cited against any competitor applications. And this so-called forward citation analysis can be used to identify possible licensing opportunities for you. On the other hand, where you are looking to exploit the new technology, then to avoid infringing a third-party patent, it can be more cost-effective for you to take a license or otherwise acquire the patent by a one-off purchase. Alternatively, if licensing or purchasing a patent is not an option, then, as I mentioned previously, we could consider attacking a patent and invalidating the patent so that you are free to commercialize your technology. This is referred to as often clearing the thicket, clearing the patent thicket. And it's also useful to keep a watchful eye on your competitors to see what they're up to. For example, are they diversifying into a new area of technology? Are they looking to use similar trading names to yours? This information can be key and can help you make the important commercial decisions. So Wynne-Jones has extensive experience of IP budgeting and competitor and IP analysis and other strategic tools which will help you align your IP with your business plan. So please talk to us to see if we can help you. We can also help with protecting your rights. We can carry out audits to help you identify the main rights to consider to protect for your products. So feel free to give us a call and we'll be happy to help. So I'd like to thank you for attending this presentation and I hope you found it useful. If you do have any questions, then please drop me an email or drop them in the comment section. I don't think we've had any questions. I'm just having a quick look in the comments box. I can't see any questions, but like I said, feel free to drop me an email with any queries and I'll be happy to respond. Thank you. No questions? Okay. Thank you.
Thank you for watching. Rewatch all of our sessions online. Thank you to our partners.